Well, welcome everyone for today's webinar, Testifying at Dependency-Neglect Hearings as a Therapist or Service Provider. I'm going to let our speaker, Elizabeth Manso, introduce herself here in just a second. But before, I wanted to go over a couple of housekeeping items. As always, if you would like to ask a question during the presentation, use the chat feature, which is on the right side of your screen. And if you need or would like to earn 1 CEU, please stick around to the very end. There will be a code that's given. You'll need to email that to me. And we only give out CEUs for folks who attend live webinars. So if you happen to be watching this on YouTube, we only give out CEUs for attending live webinars. And as a reminder, this webinar is being recorded, and we'll upload this presentation to our website. And before I hand this over, we kind of wanted to ask folks a question, throw it out there to kind of start things off of who you primarily see as clients. So I'm going to ask everyone a polling question here. And so do you primarily work with clients who are children, adults, or both children and adults? We just want to get a sense of who folks work with. Let's take a couple of minutes or so to help answer this question, and then we'll get started, and I'll turn it over to our presenter. So again, if you just joined us, we have a poll question up there. Do you primarily work with clients who are children, adults, or both children and adults? So if you could just answer that question, and we'll get started here. Last call to answer the question. It looks like most folks, it's kind of split. Either they work with children or both children and adults. Doesn't seem like anybody exclusively works with adults. All right, I'm going to turn it over to our speaker, Elizabeth Manso.
Hello, everyone. Thank you for participating. My name is Elizabeth Manso. I hope everyone can hear me well. And I am an attorney ad litem. Specifically, just to give you a little information what it means to be an attorney ad litem, I am an attorney licensed here in Arkansas. There is additional qualifications that an attorney ad litem has to complete, which is an initial training and CLEs in addition to just what normal attorneys have to do. And in case you've not heard of attorney ad litems before, we are appointed to represent children in dependency-neglect cases and also domestic relations cases in some circumstances. But this presentation is specifically for those attorney ad litems that represent juveniles in dependency-neglect cases, which some people may also know as foster care cases. There are some disclaimers here. Of course, I am only giving general information regarding dependency neglect cases. I cannot answer specific questions about cases or people, so you'll need to direct those to your attorney at your agency or talk to your supervisors at your agency. And none of this is meant to be legal advice. And when I say general, your specific court that you may be asked to testify in may have their own court rules. Judges have their own rules, and of course attorneys have their own way of doing things. So it could vary a little bit. What I want to talk about just in general is some things such as what you need to know about being asked to testify, how to prepare to testify, what you can expect in court, what things you may encounter in court, and of course why all of this is even important, why it matters. So if you have been asked to testify in court, there are different ways that could be done. One thing to keep in mind is who's asking you. Is this your client that's asking you? Is it an attorney? Is it a family service worker? And that matters because it kind of distinguishes whether it's an informal request or a formal request. So if it is a client, not his attorney, but just your client or a family service worker asking you to attend, then normally it's just, just by conversation or email. And if you agree to come, there really is not enforceable. If you ended up not showing up, there's not really much recourse there. However, if an attorney is asking you to appear, you may get a subpoena. If you've not received a subpoena before, subpoenas are legal documents. It's enforceable, and we will get into a little bit more as to what a subpoena is and what makes it enforceable. But, of course, you could be asked informally by an attorney to come to court, and again, that's not going to be enforceable. So if you receive a subpoena, the next thing you're going to want to know is, what does that mean? So this is a sample of what a subpoena looks like. This is one of many versions of what a subpoena can look like, because this is what's provided on the court's website. And attorneys could take the same information and create their own document, but it should still have the same parts in it. And let me go back here. What you're going to need to look for an enforceable subpoena is it needs to be issued by either a clerk of court or an attorney. It is to practice in Arkansas. There's certain things that need to be in it: the name of the court, the time and place to be, and what's also very important is whether it's asking you to produce documents. All of that can be in one subpoena. If it's a subpoena for you to appear and to produce documents, it'll be in one subpoena. And what you need to look for is just that any request for documents is fairly specific and not unduly burdensome. So if you've been practicing for the last 50 years and the subpoena is asking you to bring in every one of your case files since you've been practicing, then of course that's unduly burdensome. And you could have some recourse as to not have to bring in all those documents. The subpoena itself must be served in certain ways, and most commonly it'll either be sheriff or it'll be by mail. When it's by sheriff, it does have to be specifically a sheriff that is in a county in which the document's going to be served. It can be by phone. A sheriff can serve you by phone. Of course, it needs to be in a county of where you reside. If it's going to be by mail, it's usually because the attorney is serving you by subpoena. It needs to be certified mail with return receipt requested. That's the green card. And it has to be restricted delivery. And then you should get the subpoena at least 2 days before the hearing. Of course, a court can shorten that time, but that's what the norm is. And it should also include a witness fee of $30 a day and 25 cents a mile for travel from your residence to the courthouse. So that's kind of what a formal subpoena would look like. And what that means is if it doesn't meet these criteria, then it may not be enforceable. Of course, there's always exceptions and conditions to that, and we can't get into all of it, but if you have any specific or general questions about that, you can ask, or you can email me. I've got my email address at the end of the presentation. So a lot of people may want to know, what if I get a subpoena and it looks legitimate and I don't want to go? Noncompliance for a subpoena is you're basically subject to contempt of court. So if you fail to appear or you intentionally evade service by concealment, then you may be held in contempt and have to come to court to answer for that, and you may be subject to jail time and or fines. So if for some reason if you get a subpoena and for some reason you cannot attend, then you'll want to contact that attorney and that sent you the subpoena to see if there's some other arrangements that could be made. You'll want to talk to this attorney that sent you the subpoena anyway. In most cases, you already have. As an attorney, you usually don't have people testify in court unless you know what they're going to say. And so they've probably already talked to you before having you come to court. But if not, the attorney's information will be on the subpoena, at least the name and address. If there's no phone number, you can go to the Arkansas Bar Association's website, and there's an attorney directory, or you can call the Bar Association and get the attorney's phone number to give them a call. It's also a good time if there's any special accommodations that you may need, whether it be, if you need wheelchair accessible areas, if you have any other medical needs, you'll want to let the attorney know too. If you need an interpreter, if you need hearing devices, audio-visual equipment, that type of thing. So I know a lot of people want to know, okay, I can testify in court, but what about privilege and confidentiality? And of course, you all do have a confidential relationship with your clients. Specifically, the statute does address counselors, therapists, social workers, drug and alcohol counselors, and also psychologists and psychological examiners. But of course, there's exceptions, and that's what we'll kind of talk about next. So when someone considers whether there's an exception to confidentiality, then the questions are going to be whether it's privileged communications. And if it is privileged, has there been a consent by the client to reveal the information? Are there legal exceptions? Is there an existing court order to release the information? And then sometimes also, who's asking you to reveal it, even if it's not a written consent? If your client is asked you to come to court, I think you can be assured that confidentiality for your client's not going to be an issue because he's wanting you to reveal information in court. In dependency neglect cases, often there are orders from just the beginning of the case. When the Department of Human Services files a petition to have court involvement in a case, the judge will sign an ex parte order, which just means an order without a hearing. If the court does grant the DHS's petition to bring the child into foster care or open a dependency neglect case, the court will often also sign an order to obtain and disclose protected health information, and this will set forth who gets the information, so the attorney ad litem by name, any parent counsel, also CASA, which is court-appointed special advocates, may have access to those records. So this order here may already be in place. If you have the subpoena, it's legit, and you're going to be coming to court, you'll want to start to get ready to testify. You'll want to, of course, review your case file. You'll want to do that because you'll want to be familiar with the case from the beginning. A lot of times what you'll need to be prepared to talk about is dates. You want to be able to give the court a timeline of your services. Most dependency neglect cases work on a one-year timeline. Of course, there's a little wiggle room there, but in that one-year timeline, we need to know where your services are, where are the services completed. So what we look at is at the time of removal, from the very beginning of the case, we have a trial, then we'll usually have a 6-month review, and then a 1-year permanency planning hearing. And then after that, or within that time, we may have additional reviews. And so that's why dates are important. If you're testifying as to something happening, we need to know in what point in time within our 1-year time frame are we talking about. We also need to make a note if your client was participating in services. Did you have any recommendations as part of your services that you provided? Those are all things that are going to be important in dependency neglect cases. If you used any research or assessment tools, go ahead and become familiar with those. And then, of course, you'll want to make sure that you're familiar with your professional standards and ethics and any agency policies you may have, just so that you're not violating anything there unintentionally. Some of the things that you'll need to bring to court is any of the items listed on the subpoena. If it's asked you to bring documents, bring your case file, any of the assessments or evaluations that you plan to testify from. And also, of course, you can make notes, but something that's very important to understand is whatever you use on the stand, whether it's to refresh your memory or that you're going to testify directly from, then it is subject to review by the parties and their attorneys and the court. So if you're going to make notes, I would make sure that they are of such that you would not mind someone else reading. And I think you probably have to have a good idea what I'm talking about there. So when you're actually at court, I know some of you probably have already been to court before, so I'm not going to go into a whole lot of detail. But you're basically going into a confidential and closed court proceeding, so public is not going to be in there. And with that in mind, depending on the court, it will depend on who's allowed in the courtroom. Some courts are very strict and only the parties and their attorneys are allowed in the court, so you may have to sit outside the courtroom until you're called to the stand. Other courts will allow everyone in. So if you are in the court, some of the people that you're going to see, of course, is the judge. There could be a special judge sitting in for that particular hearing. The law clerk, who isn't an attorney, is sometimes in and out assisting the judge. Trial court administrator is responsible for the calendaring and scheduling. Of course, the court reporter, which varies because you'll have some that wear a mask to record the proceedings. Some use a stenotype machine, but they're almost always recorded and you'll see microphones in there. And then the bailiff, who is there to kind of manage the people. They tend to be police officers or probation officers. People that might be in there are foster parents, relatives, fictive kin. Fictive kin are people who are not related but are maybe there's a relationship that's so close that it's like they're a relative. Law enforcement and other service providers may be in there. This may be kind of common knowledge for most people, but when you go to court, look professional. Don't wear revealing clothes, but also don't wear loud jewelry. These microphones sometimes can pick up a lot, and if you've got clanging bracelets and clanging earrings, it can be very distracting. So just keep that tone down. Do not record either visually or audibly the recording of the proceedings. That will get you in really big trouble. So don't bring your phone in. If you do, make sure it's silent and make sure the bailiff knows that you've got it on you. You will have to take an oath, and the wording of it itself varies, but you're basically saying the same thing, that you're swearing or affirming to tell the truth. Raise your hand. When you answer, you have to answer out loud. So if you, of course, are going to swear or affirm, then you're going to say you do. Once you take the oath, you're going to remain under oath. So if you are asked to leave the courtroom to wait outside and you come back in, you're still under oath. So after that's done, you may hear an attorney say that they request the courtroom to be cleared or they invoke the rule. Those are just two things that basically means you're going to have to sit outside the courtroom. Clearing the courtroom is just a way for parties to enforce the confidentiality of the proceedings. If you're not a party to the case, you don't really have a right to be in the courtroom. That is a lot of times up to the judge's discretion. However, invoking the rule is a statutory accommodation where if there's a witness in the courtroom and the parties do not want that witness to hear the testimony because it may influence their own testimony, then they will invoke the rule and that witness will have to sit outside until they're called to testify. So if you are sitting outside the courtroom, do not discuss the case with anyone, and the judge may even tell you that. But also, of course, keep your voices down. Don't leave the area unless you've let the bailiff know. So it means you're going to have to ask the bailiff if you can go to the restroom. Please do so, because it normally turns out that as soon as you leave, that's when they need you. So don't wander. The parties, and I've said the parties several times, and I'll say it probably several more times, but specifically when I say parties, I'm talking about the people named on the lawsuit paperwork itself. So the plaintiff or petitioner is DHS, Division of Children and Family Services, when we're talking about dependency-neglect cases. And they are represented by the Office of Chief Counsel, which is their attorney. The defendants can be a range of people from the parents, the mom, the dad, guardians, and when I say dad, of course, there's many different versions of dad, but these are all the people that have some type of legal right to the child. Sometimes you'll see the word pro se. It means that it's a parent or a party that does not have an attorney, so they're representing themselves. But if they're not pro se and they have an attorney, we'll normally refer to them as parent counsel, which they can be private attorneys or they can be court-appointed. They do have to meet some income requirements and be found indigent in order to get appointed an attorney. And only the person from whom custody was removed gets a court-appointed attorney if they qualify. I know a lot of people will ask why mom has an attorney but dad doesn't. Well, custody was probably removed from mom and not dad. The juveniles are also listed on the legal documents, but they're not technically parties to the case. There's no allegations against the juveniles often, so they're considered respondents. And juveniles, by law, are appointed attorney ad litem. So all juveniles in dependency-neglect cases will have an attorney ad litem, whether or not they're in foster care. And that's important for you all to know, because when you have a client who's a juvenile, or you have a client that gives you information that might be important to a juvenile, they have an attorney ad litem. So it's a matter of finding out who that person is in order to get them some important information. Okay. When you are called to the stand to testify, it may seem like there's no rhyme or reason, but there is, and you're going to get a lot of questions coming from a lot of different places. The person who calls you to the stand will conduct a direct examination of you. Now, the person who calls you to the stand may be the person who sent you the subpoena, or it may be somebody else. The normal course of questioning is that the petitioner or the plaintiff questions first. And so in our cases, in dependency-neglect cases, it's normally DHS. So the DHS's attorney will ask the question first. After they're finished, then the next in line varies a little bit. It's either the attorney ad litem or it could be the parent's attorney or the parent themselves if they're pro se. So if you're called to the stand by DHS's attorney, they will, on direct examination, ask you normally open-ended questions. They're not allowed to lead you. What that means is they can't ask the question that has the answer in the question. So, for example, if they ask you, did you think the mother's reaction was inappropriate? Well, that kind of tells you what the answer might be, and so somebody may object to it. If the department or DHS has finished questioning and now it's moved on to the attorney ad litem or the parent counsel, what they're going to then do is cross-examine you. These can be leading questions, so they're a lot trickier, so you have to listen very carefully. Because if I ask you, did you think the mother's reaction was inappropriate, maybe you think it was inappropriate under normal situations, but not under that specific one. And so if you just say yes or no, you may not be giving the full answer that you want to give. So you really do need to pay attention and listen to them carefully. Once the parent counsel and the attorney ad litem have finished asking their questions, then DHS's attorney then has an opportunity to redirect, which is ask you questions based on what you've already testified to. If they go outside the scope of that and ask you questions as to things that you did not already testify to, then somebody can object and say that it's outside the scope, and then the judge will make a determination. Then at that point, it goes back around the lineup. So then the attorney ad litem or parent counsel can then re-cross-examine you, and it can keep going until the court feels like it's heard enough. And then anywhere in there or at the end, the judge can ask its own questions of you. Of course, when you address people, you've got the judge as your honor, or Judge so-and-so, Judge Smith, Judge Jones, whatever. But what's important about testifying is names. You have to be careful about using first names, nicknames, and pronouns, because oftentimes these cases have a lot of people involved, and if you say something like, he told me that she went to their house and they saw him there, no one will know what you're talking about. So use first and last names, or just Mr. So-and-so. That will help clarify the testimony. You also have to be aware that if you are called as a witness for one party, then the other party may not like what you have to say and may get rude or disrespectful. I would not take it personal, but you do need to remain composed. Don't get overly emotional or show anger. You need to maintain credibility. The other thing I would very much want to let you all know of is that in the near future I'll be talking to you about hearsay, because I know that's something that a lot of people have questions about, and I'll get into more detail later. But when you answer questions, don't anticipate a hearsay objection. I've been in court where a witness will be asked a question and they'll say, I can't answer that, that's hearsay. Well, it's the attorney's job to make those objections. Sometimes attorneys aren't paying attention, and that's their job, and so if they miss it, that's their fault. And sometimes they don't mind having the person say what is hearsay, and so just answer the question that's being asked. You also need to answer out loud. The court reporter is recording along with the microphones. Saying shaking your head is not going to be recorded accurately. Think about the testimony that you have, the result being a script, like a movie script. So anything you say needs to be in that record. In addition to that, don't talk over other people. If you are talking and an attorney interrupts you, then just stop. If an attorney is asking you a question and you haven't finished your answer, then go ahead and just stop. But we need to keep that record clean as possible. When you testify, don't guess. If you're guessing, then you're really of no use. Anybody up there can guess. But if you're estimating, it's okay. Just let us know that you're estimating. And the estimation, just be prepared to have to explain what the basis of your estimate is. But it's okay. It's also okay if you don't know the answer. It's okay to say yes or no or I don't know. Just be honest and don't try to mislead anybody. Don't get mired down in the semantics. Just quick, short answers are always the best. And I've talked about some of this already, but I also want to stress, because I've seen this happen a lot, stop talking when you've answered the question. I think some people are uncomfortable with silence and feel the need to fill it with volunteered information, and this is not an appropriate place to do that. Just if it's a yes or no answer, then just leave it at that. If there's more information that you feel like needs to be presented, you can say yes, but there's more to it, or yes, but I'd like to explain, and then you usually are given the opportunity to go further. But please do not start testifying on your own rogue without, being responsive. That also can result in objection, too, as being a non-responsive or volunteering information. Something else that people, I think it's second nature to do, if you're not sure of an answer, you'll look at the client or look at someone in the courtroom and ask them, wasn't it at 1 o'clock that you came by? For example, that's not appropriate. Also, don't look for confirmation from people in the courtroom by nodding your head or having them nod their head. That's also not appropriate. If you're unsure, you can just say, I'm not sure. So I mentioned some things that could elicit an objection. If you hear someone say I object, or objection, just go ahead and stop talking. At that point, normally the attorney or the pro se client will say why they're objecting, and you have to give the judge an opportunity to rule on the objection, whether it's overruled or sustained. If it's overruled, that means you can finish your answer. If it's sustained, it means you can't. If you're unsure, because sometimes attorneys will immediately withdraw their question before the judge rules, or you can't remember what overrules and sustains means, then just ask the judge if you can answer the question, and the judge will let you know. As a witness, you're kind of categorized. You may be a fact or lay witness, or you may be an expert witness, or a combination of the both. What's important about the type of witness is what you can testify to regarding your opinion. If you're a fact or lay witness, you're testifying as to what is in the knowledge of an ordinary person. If you're an expert witness, you're allowed to give your professional opinion. And that's important because if you are a fact witness, this is based on your first-hand knowledge. It's about what you've witnessed, what you've seen or heard. For example, she looks scared. That's what you saw, and that's what you're testifying to. And it doesn't require any expertise to know, if you feel like someone looks scared. However, if you're an expert witness, then you do require to be qualified as such by the judge, and there's a process to that, which usually commences as soon as you take the stand. As an expert witness, you basically have specialized knowledge that you're going to offer up to the court to help the court understand the evidence or determine facts. And so as such, the attorney that's calling you to the stand and asking you to be qualified as a witness will have several questions for you about your education, your work history, things like that. You'll want to bring your resume and or your curriculum vitae so that that's available to the court and to the other parties. And once the attorney has answered or asked all those questions and they've been answered, the attorney will ask the court to have you qualified as an expert witness in some area, whether it's specific or broad. And then the court will make that determination. Other questions, the other attorneys may have questions about more details as to why you should be considered an expert. But if you've ever been qualified as an expert before in a court, you should let the attorney know. Especially with dependency-neglect cases, sometimes you may find yourself in the same court on more than one occasion. And the parties and their attorneys can just stipulate or agree that you're an expert without having to put on all the proof and have the court determine that. So that's kind of a shortcut. So please let the attorney know if you've been previously qualified in a court. But as a witness, you are subject to more detailed questions about your methodology, how you came upon the opinion that you're giving. So just be prepared for that also. And of course, like I said, you will be able to give your opinion, and you can give that opinion without disclosing the information or the underlying facts. However, just be prepared that on cross-examination, the other attorney probably will ask you what the basis of your opinion is. And so be prepared for that. You may also be asked questions that are hypothetical. And for example, based on the information that you have, if you found out that mom was still testing positive for drugs, what would your recommendation or what would your opinion be? That's, of course, a hypothetical, but you would be allowed to answer that type of question. Sometimes you'll hear people use very specific wording. Specifically, is your opinion within a reasonable degree of, for example, medical certainty based on your education, training, experience? I included this because some people are under the impression that this has to be said, and it is not. So if you don't hear that, it's okay. You can still testify. So I have some questions up here just to give you an idea of some situations. I'm not going to read them all, but for example, number 3, Jane is suffering from major depression. Well, that's a diagnosis, and so that would require an expert opinion. However, number 5, Jane seems scared of her mother, then that would be more of a layperson opinion, and so you don't have to be qualified as an expert to answer that question. So these are just questions to think about. If the notes may be available with the presentation and the answers are in the notes. So now we get to hearsay, which is a big one that a lot of people ask about. Hearsay specifically is a statement other than the one made by the declarant while testifying at the trial or hearing offered in evidence to prove the truth of the matter asserted. So basically what we're saying is it's some type of statement which can either be oral, written, or even just nonverbal conduct that someone is saying is happened, it's true, it's happened. Well, hearsay is not admissible unless there's an exception. But for our purposes, what's usually the case when it comes to someone who wants to say, well, mom told me this, or dad told me that, well, it's not hearsay if it's admission by a party opponent, which means that if mom is a party to the case, then any admission she makes is not hearsay, and so it comes in. It can get a little confusing, and there are several exceptions to hearsay, and that can be a whole training on itself, and not even all attorneys are really comfortable with all the hearsay exceptions. But for the cases that we're dealing with in Dependency-Neglect court, admissions by party opponent is really important to know, and then we will also talk about court reports that you may prepare for court that will also be important to know about hearsay. So I did a couple examples here, and again, the answers are in the notes, but just to do one example, the question might say, when I asked Jane if she used drugs today, she nodded her head. So, is this hearsay? Well, is Jane a party to the case? If yes, then it's not hearsay, so it can come in. It's an admission by a party opponent. However, if Jane is not a party to the case, then it is hearsay, so then we have to look at whether there's an exception. And just because she just nodded her head and didn't say yes or no, that's still considered hearsay because it's a nonverbal expression. So all of this matters for one overriding or overarching issue is we're talking about the best interest of children in dependency and neglect cases. Best interest is the paramount standard in dependency and neglect cases. It's what the court is always or should always be thinking about whenever it listens to the testimony and looks at evidence. And as a therapist or other service provider, you may be the only one who's in a position to know what is either in the child's mind or in the parent's mind, and that information is necessary for the court to make its rulings and make its decisions. It's also important because that's why we need therapists and service providers in court. I know it's very difficult to have to put your practice on hold while you sit in court, which could be hours, but when you create court reports, they don't necessarily come in because they're hearsay. There are some exceptions, but the whole idea is when you have a court report and it's presented in court, then it states your opinions and it may state some facts, but the opposing party does not have an opportunity to cross-examine that report. It can't ask questions about where you came up with that opinion or who told you that fact. And so when you're not there, then it puts that other party at a disadvantage. And that's really the purpose of hearsay, is to keep out information that parties don't have an opportunity to question. So when you get a subpoena to court and you have a court report, it may be that just having you in the courtroom is enough for an attorney to not object to the court report, because they know that it's just as easy for you to get on the stand and testify, and rather than go through that, they'll just let the court report in. Those are the times that I know it's very frustrating for therapists who've taken out a big chunk of their time from their practice to sit in court and wait to be allowed in the courtroom for hours and then don't even testify. Or they get on the stand and all they do is testify that that is their court report. And I know that's frustrating, but when we prepare for court, we have to be prepared for the worst, and sometimes that means if you're not there, then your court report's not getting in. And at the same time, that means all the work that you've provided to that child or that family is not coming in, and that does everyone a disservice. Another issue to consider is if you're contracted by DHS, as part of your contract, it may be that you testify in court. So that's another reason to check with your agency's policies and supervisor about whether that's mandatory. I say all of that because while there's enforceable subpoenas, there's very good reasons why you should be there, there are ways of getting out of a subpoena, and it's usually called quashing a subpoena. I don't have enough time to get into all of that, but one of the easiest ways is if your subpoena has not been properly served on you or if it's not a proper subpoena. But I would just ask that from my own personal point of view, being an ad litem, that if you cannot make it to court for whatever reason, then contact the attorney that subpoenaed you. It's possible we can have the hearing continued to another date that is more convenient for you. And if the attorney is willing to do that, then your testimony is very important. Important to the case, important to the child, and to the family as a whole, including the parents. So at this point, I don't have any other information to give you in the time allotted. I do want to thank you for joining me. Of course, I have my email address and my office number here if you'd like to email me a general question. If you want any sources or statutes or rules or codes or anything as to anything I've testified to, feel free to send me an email and I will get you whatever information I can.
Thanks, Elizabeth. Yeah, so if folks have questions, feel free to write those in the little chat bubble, and we'll just wait a couple minutes, and hopefully folks will have a some questions, and then we'll go to the next slide that has the code for the CEU. So if you have a question for Elizabeth, go ahead and type that in. I know there's a lot of therapists out there. There's a lot of questions about expert and lay witnesses. If you have any kind of follow-up questions regarding that, feel free to ask. We're kind of a quiet group on Friday. That's okay. Yes, somebody had asked, is there a way to get a copy of the presentation? I think Elizabeth's fine with us emailing that to everyone who's attended, so I'll do that. Email the presentation to everyone later this afternoon. So.
Yes, I got a comment here about explaining why you may not testify but is needed in court. Again, there's the legal side of things that the statute sets forth when it comes to hearsay and evidence, but then there's the practical side. And as an attorney, if I foresee myself objecting to a court report because I don't like the information in it or there's more questions, then if I see the therapist who wrote that sitting there in the courtroom, then, it's really hard. I can't really object to it because I can just simply call the therapist onto the stand to answer my questions. So in that case, I'm probably not going to object to the court report and save everyone the time of the testimony. And so the therapist just sitting in the courtroom alone is enough to kind of move things along. I am fine with making my notes available, and the examples in my presentation, the answers to those examples are in the notes, and so those notes will be available.
We've got a couple of questions coming in here, so we're just kind of reading through them and
Okay, so the question is about being told as a social worker that you cannot give your opinion about the case-only facts. That kind of goes back to the issue of were you qualified as an expert or not. It's very often that social workers may not be qualified as an expert. And it's not that you're not an expert, but the attorney hasn't gone through the steps to have the court qualify you. So in that sense, you really can't give an opinion about the case. But now we go back to the practical side. If you're asked a question about your opinion, you can answer the question until an attorney objects to it. So, for example, if you are asked for your opinion and you're starting to talk and no one objects to it, you continue talking. The court will then take that information for whatever and give it whatever weight the court wants to give it. If the court itself just knows that she hasn't qualified you as an expert, she may not give it the weight of an expert opinion. On the other hand, if you're starting to give your opinion and another attorney objects to it because you're not an expert that is able to give your opinion, then you would need to stop talking at that point. And perhaps the attorney that called you to the stand and asked you that question would rephrase the question in the way that would still make it apparent what your opinion is without you saying, in my opinion. And that's kind of the nuances of the questioning in courtrooms and judges. I hope that answers that question.
So last call for questions, and if you have any general ones, you have Elizabeth's email up there, or most of you have my email. I'll be happy to forward those on to her. And a couple other questions, I think, here. But before Elizabeth answers those, the code is up there, and if you're watching with a group and only one person signed in, please have each person email me individually.
Okay, so a question about getting more information to quash a subpoena. I have in my notes the statute about what makes a subpoena valid. Of course, if it doesn't meet those criteria, then it's not a valid enforceable subpoena. If there's other ways also, which would be if you've been asked to produce documents and it is unduly burdensome, then what you would need to do is you would want to first of all, you'd want to contact your agency attorney first, because there may be some documents that they can file with the court. But other than that, and I'm going through my notes right now looking because okay. So if you've been asked to produce documents, then the court, upon motion, basically you make a formal request to the court that it quash or modify the subpoena if it's unreasonable or oppressive. So you're basically asking the court to quash the subpoena. And some people may be comfortable doing that on their own, or they may want to talk to their attorney. But I didn't really get into that detail because it's so much, it's a whole separate issue all by itself. But I would say, one, verify that the subpoena is valid and enforceable, and then two, notify the court that it's being unreasonable, and then let the court take it from there. Okay, there's something else that says, what about your notes and dates related to testimony if it was written? And information that's not written in notes, but you testify to it. You can testify to your knowledge. So even if it's not written down, but it's first-hand knowledge, then that's fine. You can testify to that. When it comes to I'm not quite sure what you're asking when you say notes and dates related to testimony. Because it doesn't necessarily have to be written for you to testify to it if it's within your own knowledge. Now, there may still be an objection because either they, hang on just a second, let me try to read these questions at the same time. You know, there really is no valid objection to your testimony if it's about information in your knowledge, whether it's written or not. If it's in your knowledge, then there really is no valid objection to it. The only objection I could think of is if it was maybe repetitive, like if the attorney's asking you the same question in different ways and the answer is the same, then that would be an objection, but you would still get your testimony in, so it wouldn't affect the information you're giving.
Okay, well, I know we're just about at the top of the hour, so I wanted to thank Elizabeth. We'll kind of hang out here for another minute or two and answer any other questions that trickle in, but if you would like your CU, please remember to email me that code. And again, if you're watching with the group, have each person in that group email me individually, and just let me know who you were with, so I know the person you signed on. So that's it. So you're free to go and enjoy your Friday. We'll just kind of hang out here for another minute or two and answer any remaining questions. Last call for questions. 30 seconds or so. Okay, well, everyone have a great Friday and great weekend. Hopefully you'll join us next month for our webinar then. Take care.